Ma'am, come on back in.
Oh, you want an example out of it? I see.
I'll make an example out of anybody. Hang on. You want to stand here?
You don't.
You want to stand here and be disrespectful?
No,
I
just
will
want
make
you
an
to
example.
understand my situation. Like,
I don't care what your
I'm not making
situation.
no excuses.
You shouldn't be using ecstasy and methamphetamine. If you have a child, you can go back with the bailiff. Go back with the bailiff right now.
It's ridiculous to me that you're saying you want a second chance, because this was your second chance. You've already been on probation. You were given the second chance of not going to prison. The fact that Ms. Holmes negotiated a cap of 8 years for you, you should thank your lucky stars. This is ridiculous.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail.
I'm not here today on special appearance.
I'm sorry, speak up so I can
Here
hear you.
today
You're appearing here today?
by special appearance.
Okay, what is your name?
I'm a third party intervener on behalf of artificial legal entity, not Nir Brown.
Okay. At one point in your, at some point in your life prior to being this third party, were you Nir Brown?
No.
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said, because you have now identified yourself as Nir Lewis Brown. And so, Mr. Brown, this is your initial appearance, and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very patient.
And at the child subject matter jurisdiction, going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer? Speak up so I can.
Up and down.
It's been up and down?
Yes.
Okay, so here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it again.
Overstand.
You overstand?
Yes.
Okay. What does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'll blind.
You'll oblige?
I'll blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay. And so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out, your bond would be raised and you would go back to jail. Do you understand that as well? You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, step in front of the clerk. Nir Brown. Are you Nir Brown?
I'm sorry. We were here before.
You've been here before, but you have to speak up where I can hear you.
Executing beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose
Yes.
hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the copy. I do
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your 2 cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
What's his name again?
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt? Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of a lawyer that's in this state that I'm not finding this is falling names.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say. Because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started.
Don't make me lay hands on you,
Why would you lay hands on me?
because you're not doing what I'm telling you. Now go.
Mr. Brown,
Go
you
back.
need to go back with the bailiff. Right now, I've raised your bonds. You have to go with the
I am not
bailiff.
a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are
I
hands
told
being
you. I told you I was gonna put hands on you.
Why are hands being put on? Y'all see this on the camera?
Stand right there. Put your hands on the wall. Okay. Put your hands on the wall, because you're not listening. Don't listen. I don't advise that.
Good morning, ma'am. Are you Brittany Davis?
Yes.
And Miss Davis, did you get someone hired?
No, it's kind of expensive, but
Who'd you-
really expensive. I'm not even working right now. But I went through
Who'd you talk to?
the legal aid. I put in an application for legal aid.
Okay.
It's a place that help you get a lawyer, but they say it could take 6 months to a year. So
Okay. So did you talk to any other lawyers like I told you to?
the first 3 that I talked to, wow, I talked to like probably 8 of them. But the lowest there goes like 2,000 to start off.
Do you have the names of the lawyers that I asked you that you talked to?
You asked me that last time. I was on.
Right. And then I reset you to talk to them more or get someone hired. So
I
did you
talked to
talk?
Renshaw. I can't remember their name. Renshaw. There's one that's brothers.
Why wouldn't you write that down and bring it?
I wasn't expecting that I had to.
So it looks like you weren't what?
I wasn't expecting that I had to.
So if you're okay. If I tell you to go talk to some lawyers and bring me the names of the lawyers you've talked to, and you don't think you can remember them, then I would think just common sense would tell you to write them down so that you could tell me that you did what I ordered you to do so that you wouldn't go back to jail, right?
I did do what you ordered me to do.
Okay, so
first time.
I ordered you to bring back the names as well, not just talk to them, but bring back who you talked to so that I know who you talked to and that you're doing what I asked you to do, right? Right?
The cheapest ones that I've given you the last time I was here is the main ones that I was looking into.
Okay. But when you left last time, I gave you specific instructions,
Okay.
right?
Right.
Okay. So are you wearing your drug patch?
Yes, ma'am.
So it looks like back on second. So you tested positive since you've had that drug patch on for methamphetamine.
What is that?
What does that mean?
I don't. But what with the patch?
Mm-hmm. Looks like you tested positive for methamphetamine, cocaine.
Uh,
Hold on. Let me print it out so I can read it better. So last time you were in here, you had an issue because you had showed up with your drug patch in your hand, so they couldn't test it. So I tested you in court, and then I made you get the drug patch put on again and told you to keep it on. And then the drug patch that was put on January 25th, which was the day before that court date. So you had one on, you had taken it in, you put it on, tested positive for methamphetamine and cocaine. Have a seat in the jury box. I'm going to have you tested this morning, and then I'll decide what to do. Thanks. Actually, come on, ma'am. Come on back up here. I know what I'm going to do. So, Ms. Davis, obviously it is a violation of your bond conditions to use any illegal substances, right? And so you tested positive for cocaine and methamphetamine on that drug patch, in addition to in the past not having it on correctly, and you didn't do what I asked you to do or ordered you to do also here. So I'm going to raise your bond at this time for those violations to $100,000. You will keep your court-appointed attorney while you're in custody.
The courtroom pressure did not end with Nir Brown. As more defendants appeared before Judge West, the focus shifted to missed instructions, bond conditions, positive drug tests, and the consequences of failing to follow court orders. Brittany Davis explained that she had contacted several attorneys but could not afford to hire one. Judge West asked for the names of the lawyers she had spoken with because that information had been specifically requested during the previous hearing. Davis said she could not remember all the names, even though the judge had instructed her to bring them back. Then the hearing took another serious turn. The court reviewed the results connected to Davis's drug monitoring patch. The results showed positive findings for methamphetamine and cocaine. Judge West explained that using illegal substances violated the conditions of bond. Combined with the earlier problems involving the monitoring patch and the failure to follow all court instructions, the judge raised Davis's bond to $100,000. Another defendant, Melissa Taylor, told the court that she had contacted multiple attorneys, but that the legal fees were extremely expensive. However, her test results also created a major problem. The court found positive results for amphetamines, methamphetamine, and ecstasy. Judge West ruled that the results violated Taylor's bond conditions. Because Taylor had two separate cases, the judge raised the bond to $100,000 in each case and ordered continued drug monitoring if bond was posted. The final courtroom matter involved a defendant who was already on probation for robbery. The court heard that she had admitted to multiple violations, including new criminal conduct and failures to meet probation requirements. Her attorney asked for another opportunity to complete probation, explaining that she had faced difficult circumstances and lacked support. But Judge West focused on the fact that probation had already been a second chance, an opportunity to avoid prison. The judge emphasized that another robbery while on probation for robbery was a serious failure to change course. After reviewing the agreement and the admitted violations, the court found the defendant guilty and imposed an 8-year prison sentence. Judge West also warned that future criminal violations could lead to much harsher consequences. Across every case, the message remained consistent. Court orders, bond conditions, and probation requirements are not optional. When someone ignores repeated warnings, the court may respond with higher bonds, custody, or a final sentence. In this courtroom, Judge West made one thing clear. Opportunities can be given, but they must be followed by accountability.
Go back with the bailiff right now. Go back with the bailiff. Go with the bailiff.
Okay, so Ms. Dugas is on probation for the offense of robbery, a second-degree felony. We were previously here, and she entered pleas of true to counts 1 through 12, all of the counts in that motion, second amended motion to revoke unadjudicated probation. I received the updated pre-sentence report as well as a letter from Ms. Dugas. Has everyone had an opportunity to review that? Are there any additions or corrections?
None from the defense, Your Honor. No.
All right, and this was unagreed, correct? Ms. Holmes, you may proceed.
Thank you, Your Honor. I've spoken with Ms. Dugas. Obviously, the various new offenses and violations is not acceptable through probation. She understands that. She stated that throughout this time, she did not have much support. She was going through a hard time in life, and she resorted to doing and committing these offenses, not being in obviously the right state of mind to be able to successfully complete probation. Ultimately, Ms. Dugas is requesting to have the opportunity to be reinstated to complete probation, and she would like to address the court in regards to this as to her plan of how she can successfully complete if given the opportunity.
Okay, go ahead.
Ms. West. Complete this probation. I know it's going to be extended if you do gratitude. My name is John. I'm great. I'm being like I don't understand much. We'll never be sent to the world.
Ms. Dugas, you did the exact same thing. You robbed someone else while you're on probation for robbery. Not just rob someone else. You failed to ID, failed to report to probation. You committed the new offense of possession of a controlled substance. You resisted arrest it's ridiculous to me that you're saying you want a second chance because this was
Studio microphone voice 1. Sovereign Citizen Clash. What started as a routine courtroom appearance quickly turned into a tense confrontation when Nir Brown challenged the court's authority and refused to communicate in the straightforward way Judge West had requested. From the very beginning, Brown attempted to identify himself using unusual legal language, calling himself a third-party entity and repeatedly referring to a special appearance. But Judge West made it clear that the courtroom could not move forward without confirming his identity. When Brown eventually acknowledged that he had previously been known as Nir Brown, the judge continued the hearing using the name Mr. Brown. The situation became even more serious when Brown challenged the court's jurisdiction. Judge West immediately overruled the challenge and explained that the hearing was his initial appearance on 2 felony cases. She then gave him clear instructions. He had time to hire an attorney, but if he could not afford one, he needed to speak with at least 3 lawyers and bring their names back to court. Judge West also warned him that failing to follow those instructions could result in his bond being raised and a return to custody. She made sure he understood the conditions, including the order not to contact the complaining witnesses. But when Brown returned to court, the judge found that he had not completed what she had ordered. Instead of providing the required information, he continued using arguments and terminology that delayed the hearing. Judge West reminded him that the warning had already been given. Then she made her decision. His bond would be raised to $100,000 in each case. As officers instructed Brown to leave with the bailiff, the confrontation continued. He called the process unfair and resisted the court's direction. Judge West responded that saying respectfully did not make disrespectful behavior acceptable. This moment shows how quickly a courtroom situation can change when clear court orders are ignored. Judge West gave Brown time, instructions, and a direct warning. But when those requirements were not met, the consequences followed. The courtroom message was simple. Challenging the system does not remove the responsibility to follow a judge's lawful instructions.